There are various process options that you can consider when you are looking for a forum to resolve the dispute that you're in with the other parent. The starting point is obviously to try and sit around the kitchen table with the other parent and work it out yourselves. Lots of my clients manage to do that, and they manage to do that even with a bit of legal support in the background from me to help guide those decisions, but they can manage to do it themselves. If that's not going to be an option for you, then the next step up from that would be mediation. This is a great option for parents to come and sit with a facilitator who is neutral, confidential. Everyone is there on a voluntary basis to try and work out a good solution for them and for their child or children. They're not usually, although they can be, accompanied by lawyers when they go to mediation. They sit there with a neutral person who's facilitating, not judging or imposing any outcome on them. And they work from there to find a bespoke solution that works for them. I also, as I said, work as a mediator, and that is something that I work really hard to do, to try and find a solution for parents so that they've got a bespoke solution that works for their particular family, their child's particular needs and their setup. If that's not possible, there are other options along the way that involve negotiation. You can use solicitors to do the negotiation for you. You can jointly agree to appoint someone to give you an indication of what a court might do if you did go to court. And this avoids the conflict, it avoids the cost, it avoids all the stress associated with actually going to court by getting an early view. If, however, none of those options are working for you and your family, you have the court option or arbitration. In arbitration, it's a private court option, which means that you could issue your court application, but then both parents agree to come out of court and go to a private arbitration, which is where a private arbitrator is appointed who will do the same job as a judge, but do it quicker, probably more efficiently, with more time to read the documents and consider the issues. It's a more bespoke way if you've got, particularly if there's special issues. It might only be that your child has got niche activity that they need more support with, or whatever, that they will be able to help find a more bespoke solution. Failing which, you've got the court option as your fallback. This involves issuing an application with the court, and then there would be probably normally a maximum of 3 hearings where you would attend court and a judge ultimately imposes an outcome upon you. It's worth saying that both in arbitration and in a court application, it's an adversarial process. It is more high conflict. You will have to file witness statements. And this inevitably affects the goodwill between parents. And so it's something that I would always want to encourage parents to try to avoid if they can, although fully understand that there are situations where it is the safest place to be, particularly if there's been domestic abuse. It's worth also adding that in both arbitration and in a court application, either a CAFCAS officer, if you're in court, who is a court social worker, or if you're in arbitration, you would appoint a private social worker, independent social worker, will do a welfare report. In that report, they will meet your child, they'll meet you, they'll meet the other parent, they may meet other significant people in the child's life, such as a step-parent or grandparents. They may even speak to your child's school if that's relevant. At the end of speaking to all of those people, they will prepare and file a report which will set out their recommendations for what the outcome of the application should be, either where the child should live, what the arrangement should be, whether the child should go to school, or whether the child should relocate.